David Maraga, the greatness, okay. In his words, the greatness of any nation lies in its fidelity to the Constitution and adherence to the rule of law, and above all, respect to God. It is against this backdrop that the UN Faculty of Law professional body decided to have this discussion so that we may know and we may agree to disagree. What is our role and what is our responsibility in ensuring that we administer justice and stop impunity? And how well do we respect our justice institutions to ensure that it serves Kenyans in the manner intended? On today's discussion, we have two distinguished guests, and before they come in, we have Dr. Wine Mutuma, who is the patron of this professional body. Dr. Wine Mutuma is a senior lecturer at the University of Nairobi Faculty of Law. He's going to speak after this, so I'll have him introduce himself and tell you more about himself. We also have Dean Faculty of Law, Professor Winnie Kamau, again another senior lecturer at the faculty and an advocate. I do understand that we have guests who are not advocates. Just feel at home and know that you are welcome, because this topic concerns every citizen of this country. I now would like to introduce our two guest speakers, starting with the senior counsel, Mr. John Ohaga. Mr. John Ohaga is a senior counsel, that is a senior lawyer and a member of the Law Society of Kenya. And just to read verbatim his qualifications and expertise, John is a fellow of the Chartered Institute of Arbitrators and Asian Institute of Alternative Dispute Resolution and member of the Law Society of Kenya, East African Law Society, which recently appointed him to lead its arbitration committee, International Bar Association, Commonwealth Lawyers Association, Chartered Institute of Arbitrators, International Council for Commercial Arbitration, and International Association of Managing Partners, among others. He qualified as a member of the Chartered Institute of Arbitrators in 2007, was admitted as a fellow of Chartered Institute of Arbitrators in 2012, installed as a chartered arbitrator in 2018, and accredited as a Chartered Institute of Arbitrators mediator same year. He holds a certificate in sports arbitration from Kuala Lumpur Center for International Arbitration, a diploma in international commercial arbitration, a certificate in negotiation and leadership from Harvard Law School, and an LLM in international dispute resolution from Queen Mary University of London, postgraduate diploma in law from KSL, and Bachelor of Laws from University of Nairobi. Now, ladies and gentlemen, I must say that I'm enamored by this, and I think I'm really, really inspired to this point. And if you didn't know how far you can go, or if you doubted that you can hold so many titles, then there you have it. John is acknowledged as an expert practitioner in several areas of law, such as administrative law, banking, finance, constitutional law, competition law, employment and labor law, property law, public procurement, and sports law. He advises numerous blue chip companies listed on the Nairobi Stock Exchange, private companies, and some of Kenya's largest state corporations. He sits on the boards of several companies and public tribunals. He has consistently been ranked as a leading individual and recommended lawyer for dispute resolution and arbitration on local and international reputable platforms over the past 20 years. This includes the Chambers and Partners 2023 Guide for Dispute Resolution, Arbitrators in Band 1. As part of his passion and arbitration, John heads a movement of practitioners changing the landscape of alternative dispute resolution through several committees that establish policy, as well as accredit and train lawyers in the field of alternative dispute resolution. His most recent appointment has been the Governing Board of International Council for Commercial Arbitration in February 2023. Can we please congratulate him in the chat box? You can use emojis, you can use words. Congratulations, Senior. John was nominated by Kenya to the ICSID panel of arbitrators and mediators, as well as to the ICC Commission on Arbitration in 2022. Notably, he served on the Nairobi Center for International Arbitration Board for 8 years. I would like to mention something. Mentorship is a very big part of this profession, and as you take note of his achievements, I also hope that we can have him in different platforms and even individually to mentor those who are coming up in ADR. And during his talk, he'll also tell us what he thinks and what role ADR will play in all this. Our next speaker, who's the guest speaker of today, is Justice Isaac Lenaola. Justice Isaac Lenaola joined Renew and Mube Advocates as an associate advocate after pupillage. He started from the lowest point. In 1999, he became a partner and head of the litigation department at the firm of Maina Washira and Company Advocates until 2023. He served as the Secretary General of the Asset to Welfare Society and as chairman of the Legal Affairs Subcommittee of both the Olma Development Association and the Kenya Pastoralist Forum. Justice Isaac Lenaola has served as a consultant of the World Bank, the Arid Lands Management Project, Oxfam and International Union for Conservation of Nature on issues of land and resource management and conflicts in pastoralist regions. He has also participated in several international work, apart from him being currently judge at the Supreme Court. At the international level, from July 2011, Justice Isaac Lenaola has served as the Deputy Principal Judge of the Court of First Instance of the East African Court of Justice. In November 2013, Justice Lenaola was appointed by the UN Secretary General Ban Ki-moon as a judge of the Residual Special Court for Sierra Leone. As a judge at the Residual Court, he is involved in retrials, reviews, and commutation of sentences from the former Special Court for Sierra Leone. Justice Isaac Lenaola has also served as the chairman of the Kenya Magistrates and Judges Association, honorary treasurer of the East African Magistrates and Judges Association, and member of the World Council of the International Association of Refugee Law Judges. He was a member of the tribunal investigating the conduct of Pucine judges following the radical surgery of the judiciary in 2003. He currently sits in the board of the Kenya Judicial Training Institute. On 17th December 2015, CJ Willy Mutunga presented an honorary membership award to Justice Isaac Lenaola on behalf of East Africa Law Society. This is a recognition of his outstanding support and contribution to the development of regional jurisprudence and his exemplary service to the level. Ladies and gentlemen, I would like to now welcome our guest. And I know that for Justice Isaac Lenaola, we've been trying to have him for some time now, but we are here finally. Allow me to pass the mic to the President, Kihika Victor.
Thank you very, very much, Madam former President of the University of Nairobi, Melvin Thogo, and Judge and Senior Counsel Melvin has been, you know, a remarkable leader, and they have been part of the lady presidents of the University of Nairobi. We have 3 consecutive now. She was succeeded by yet another lady. So we are very, very proud of her achievements, and she played a key role in the formation of this professional body. So we are very, very honored to host you. We would have loved to see you at close quarters and take photographs and everything, but we are also most honored to host you online. We are a very young association. We were formed in February of this year, and in March, we hosted Justice Lenaola's brother from the Supreme Court, Justice William Ouko, who delivered a public lecture on access to justice and mentorship in law. Then the second event was an event for finalist students, where we had key practitioners in various areas of law, from the civil society, the judiciary, private practice, academia, just to prepare our members to transition from being a student to practice. So basically, UON LSPA tries to bridge that gap between the profession and practice. And this is the third event we are having, and we are most honored to have you. So I will now invite our patron, Dr. Kenneth Y. Mutuma, to give his opening remarks, and then invite the Dean to invite the guests.
Thank you very much, Victor. I will be very brief because I know that the gentlemen that are sought out are on the platform, and we actually want to hear from them more than from us. Let me just say that I'm very, very privileged to have Justice Lenaola present with us. The amount of expectation and the desire to actually have this interface with you has been long outstanding. For various reasons, we weren't able to get it going. And we thank you, Your Lordship, that you could make it, even if it's on a virtual platform. Of course, the student fraternity enjoy photographs. There are quite a number of paparazzis that would have wanted to stand by your side, have something documented to show that they were in a place that you graced the occasion, but I'm sure the future will be able to accommodate that. And then there is my respected senior that is also present. And what we do try and do is get members from both the bench and the bar, leading elites that can speak as seasoned practitioners. And we have none other than someone who has won so many accolades in the past. The Law Society has labeled him in one occasion as the Mentor of the Year. I think different organizations, including the Chartered Institute of Arbitrators, have recognized the role that he plays in connecting the younger professionals with the kind of knowledge and experience that the older professionals have. So very, very welcome to you, John Ohaga, Senior Counsel. A great, great privilege to have you with us. I thought I should add that bit because the essence of this program is emanates from a thirst to connect these young law scholars with seasoned practitioners. Universities, I think, have a very, very big ambition to make sure that they're not ivory towers of research, but there is a link with industry. And this forum allows us to experience that link and to hear beyond our classrooms from leading elites that are actually in practice, sitting on the bench on contemporary issues. I think the other thing, of course, is that the potential and the prospects of mentorship that grow out of this are immense. And as our Dean will shortly speak to hereafter, a few small endeavors have emerged from the past interactions with judges of the Supreme Court, where some of our students are able to connect in the places of the halls of the judiciary. They're able to lend assistance in various ways, particularly in the context of research. And then last but not least, we have our alumni. We always keep forgetting that the University of Nairobi has big people seated in high places. And as part of your CSR, Judge, we hope, even though this may take a bit of your time, you credit it as your investment back to a university that produced the kind of person that you are today. However small that input was, I hope also say the same in connection with John. This is your alumni, and hopefully every now and then you have the School of Law as part of your CSR programs each moment that you interact with us. So with those few remarks, I'd like to invite our Dean. Our Dean has been very supportive of this program. Professor Winnie Kamau, I'm not sure whether she would be a contemporary of either of yourselves, but she will tell us more. Just to make one or two comments on this topic at hand. We will have a lively discussion shortly after this. And just to tell you a bit about the kind of connections that we are making as we move forward between us and the world of industry. Karibu sana Dean, I hope you're able to unmute and you're able to speak. Let me confirm there you are. Yes. Professor Winnie Kamau, it is my great honor and privilege to invite you at this point to address us, to make a few introductory remarks. Karibu sana, Prof.
Thank you, Dr. Mtuma. I hope I can be heard.
Yes, we can hear you.
Very well. So it's really a great delight for me to welcome each and every one of you to this forum, to the Faculty of Law and to the University of Nairobi, and to this specific forum. I really am greatly delighted that you've been able to make it. As of now, I see 299 participants, which is tremendous. And I hope that even as we go on, we will have more people joining. Allow me to make special recognition of our guests, our chief guests, that is Mr. Justice Isaac Lenaola, Judge of the Supreme Court of Kenya, who will be giving us a keynote address, as well as Mr. John Ohaga, Senior Counsel and Managing Partner of OK Advocates. I think we are really, really privileged as a Faculty of Law to have these two distinguished guests. I am known to both of them personally. Mr. Justice, Honorable Mr. Justice Lenaola, has been a judge of the High Court before his appointment to the Supreme Court. I had the privilege of doing some research in his law courts when you were presiding judge at Machakos Law Courts, and you were so kind and gracious in allowing us access to your court and to your records as we carried out research on the social context of judicial decision making. Mr. Ohaga is actually my contemporary at the law school. We both attended the law school around the same time, and his partners in OK, Mr. Tom Onyango and Mr. James Ocheng, were my classmates. So again, these are people that are really close to me and dear to me. So it's a great honor and privilege to welcome you, Judge Lenaola and Mr. Ohaga, Senior Counsel, to this forum. Welcome back to your alma mater, even though virtually. We would, as everybody is saying, have wished to host you physically, but we do understand the times that we are in. But I think it's also an opportunity that the virtual platform allows scope for more people to attend this forum. So in a way, it is a blessing in disguise. But of course, we would, in the very near future, love to have you with us physically. So I'd like to, once again, welcome everyone who's joining us, the students of the faculty, and particularly the University of Nairobi Law Students Professional Association, and such students from other universities as well. I believe they are members of the academic fraternity, members of the League of Profession, and just any other interested citizen and friend. Welcome very, very much to this forum. This is indeed an important one, the forum and the topic on the topic which is on ending impunity, enforcement of the law, ending impunity and enforcing administration of justice. As we know, in Kenya, we have a lot of laws, but many of them are not enforced. So we are not able to effectively enforce laws that we have. And the judiciary, both the judiciary and the legal profession, play a key role in ensuring adherence to the rule of law, promoting transparency and accountability, and ensuring that justice is served. Efficient and fair administration of justice. Therefore, given the important roles of the judiciary and the legal profession, then we do not have any better person that can speak to us on this issue than our current guest. That is the Honorable Justice Isaac Lenaola, eminent member of our judiciary, as well as Mr. John Ohaga, Senior Counsel, and a preeminent member also of the bar. Triple OK is actually rated as one of the leading law firms in the country. And I think the bios that have been read of both Judge Lenaola and Mr. Ohaga speak more than I can about their achievements and about their contributions to the rule of law in this country and even beyond. So I do look forward very much to the deliberations of this afternoon. We look forward to your keynote address, Judge, and to the discussion by Mr. Ohaga, and then the ensuing Q&A session where our students and other participants will be able to engage with you. So I really do wish all of us very good deliberations, and I'm looking forward to being a part of this as well. Thank you, Dr. Mutuma, for acting as patron of this nascent organization, as well as to Victor Kihika, the chair or president. Thank you, Melvin, our immediate former president of the Students' Council, and to all our other officials for organizing this forum. We do not take it for granted because it takes a lot to get something like this going. So thank you very, very much. And without further ado, I would wish then to welcome the Honorable Mr. Justice Isaac Lenaola to give his keynote address. If we were in a physical space, I would have asked that we give you a standing ovation and live applause, but permit us just accept that we are grateful and that we are applauding in our hearts. And we have emojis also that show applause. So if any of us is able to do that, to signify that. But thank you very much, and welcome, Judge, to give your remarks. Asante.
Well, thank you very much, Professor Kamau. Good afternoon, everyone. And let me begin by thanking Dr. Mutuma and Melvin and Victor and members of your council for the invitation to speak to you this afternoon on a subject that I consider exceedingly important. Two quick things by way of introduction. Number one, Victor, the CV you read was for a stranger. That CV didn't look like mine. It is so outdated. I don't know where you got it from. I was expecting you to have asked me for my latest CV, which is more juicy, more catchy, more interesting, and which puts me in a better state than my 2001 CV. But that was with a light touch. But I'll send you my current and more agreeable bio. Number two, you may wish to know that John Ohaga and I come a long way. John Ohaga was my senior at high school. So I met him in 1981. When were you born, some of you? Later, we were part of the first group that moved out of the main campus to set up the Parklands Law School, which was previously the Government Secretarial College, a year before 1988 when we moved there. John was a year ahead of me at law school, but 3 years ahead of me in high school. So I've known him for a while, and we mostly think alike. To the subject then, first, I think we must contextualize impunity. And to do so, we must begin by the state is expected by its own laws, if it's democratic, and by its constitution, if they have one, to maintain law and order, peace and security within its territory. And the structure said there are laws underlying law enforcement philosophies and concepts vary across the world. In Africa, we have very different legal regimes. Some, obviously, because of our colonial heritage, differ from one part of Africa to the other. The French set up their own system, the British set up their own system. We inherited them, and we suffer some of the excesses to date. In Kenya, obviously, our heritage is British, our laws are British, and whatever changes we made over the years have not lost the fact that India in 1895. But very quickly to today, I was involved in the review of the constitution process, and that's why I said my CV doesn't speak to my experience, because without a mention of the fact that I was a member of the Guy Commission, then my CV looks chwara, it looks for. One of the reasons we set up that process was we wanted a constitution that would embody our national ethos, our values, our unique indigenous practices and customs as of today, as of 2010. And therefore, we have tried to move away from the British systems that we inherited in 1895, and today the constitution should speak to us as Kenyan people with their own uniqueness as Kenyans. And therefore, Article 2.1, for example, is the fulcrum around which our constitution must rotate. It says that Kenya is a state ruled by law, and our constitution is the supreme law of the republic. And that is important because it also says we are all bound as persons and organs at the national and county levels in enforcing that constitution. And later you'll understand why that is an important and paramount introduction to my presentation. I will focus more on the judiciary's role in enforcement of the law and the fight against impunity. And in saying so, I think we all know that the judiciary is central in the enforcement of laws, and the Constitution specifically orders us, decrees the Constitution, the judiciary, to uphold the rule of law and enforce the Bill of Rights, and therefore also ensuring that the executive and legislature do not overuse or misuse the powers granted them by the Constitution. But we also know, as is a fact, that even with a good constitution such as ours, and good laws such as exist in other African countries, states do not ever follow them, if they do, and impunity is rife across Africa. Human rights abuses by both the government and private actors are the norm across Africa. Blurring of roles between government agencies is widespread. Public officers often act as the reverse of the powers granted to them. And speaking for myself, the failure to obey court orders is, as you know, commonplace. And therefore, there is need for a conversation like this, especially by you budding scholars, to ask the question, how shall we, in enforcing our laws, attempt to end impunity? Because impunity can never end. All we can do is make the attempt to end it. Later in the paper, in my presentation, I'll focus on Kenya, South Africa, and Nigeria, and whether their laws, their practices, their customs have in any way impacted on the fight against impunity. And that is by way of introduction. Let me now go to understanding the enforcement of laws. What is it that when you say enforcing the laws? It is, in my view, state agencies acting in an organized manner, discovering, deterring, rehabilitating, and granting reliefs, including punishing persons who violate the rules and norms governing societies. These enforcements for any country must ensure respect for a public's integrity system, and only then can we ensure that misconduct by public officers and officials is curbed. Law enforcement, in that case then, can be understood in two ways. It can be public or private. Public law enforcement, which is the more commonly understood one, occurs where the government agency or actors investigates requests for information, interviews persons, inspects firms, and investigates breaches of law. And then they bring the case before competent authorities such as courts or tribunals, and then punishment, deterrence, whatever relief is then granted. Private law enforcement is where individuals bring actions against infringers to force them to end illegal activities or compensate them. In this country, the most of the known private enforcements is private prosecutions by private individuals against private individuals or against the state. Of course, we know that public enforcement is the more common than the private prosecution that we've had. But what is impunity? I could simply say impunity is what Chief Justice Emeritus Mutunga used to say, the utadu factor. Utafanya, whatever I do, whatever you think I've done, what can you do anyway? Utadu, utafanya, as you guys would say in your colloquial English. But there is debate, in fact, across the world as to what impunity means. But the UN, in its updated set of principles for the protection and promotion of human rights through action to combat impunity 2005, defined impunity as follows. The impossibility, and please underline the word impossibility, de jure or de facto, of bringing the perpetrators of violations to account, whether in criminal, civil, administrative, or other proceedings, since they are not subject to any inquiry that might lead to their being accused, arrested, tried, and if found guilty, sentenced to appropriate penalties and to make reparations to their victims. So two important considerations from the UN guidelines. One, it is an impossibility to bring these characters to face action. And two, the fact that nobody is allowing them to be subject to inquiry, which might lead to their being punished. What is de facto impunity? It is when the state fails to prosecute those responsible for human rights violations due to lack of capacity or will, or obviously often for political reasons. And de jure impunity is when laws or regulations are either too limited or explicitly provide immunity from prosecution, extends and strengthens the impact of de facto impunity and protecting perpetrators of human rights abuses. So that both de jure and de facto will arise where either there is a positive action to insulate perpetrators from a punishment, or the non-action by states or actors within the state. UN Special Rapporteur El Hadji Guse further defined impunity as the absence or inadequacy of penalties and or compensation for massive and grave violations of human rights of individuals or group of individuals. This definition is applicable to civil and political rights, as well as economic, social, and cultural rights, and also to collective or communal rights. But if you don't even carry the UN definitions, just carry what our Msema Kweli, Black's Law Dictionary says. It says impunity is an exemption or protection from punishment. Simply an exemption. You understand why this is an important definition. I think we all know and must accept that impunity is often the primary obstacle to upholding the rule of law. And impunity can result from political decisions and also from absence of judicial mechanisms that can be applied to judge a failure to comply with established rules. And we also know that where there is a mockery of human rights, when the actual violence, and all this, while the perpetrators are well known, when they go unpunished, then impunity will have found its place in any state's laws. And how does impunity manifest itself? And I'm sure that's what you wanted me to speak about. Ordinarily, protect and insulate perpetrators, or practices that generally allow perpetrators to go scot-free. And incidentally, it is very easy for a state to use the constitution to encourage impunity. When I was at East African Court of Justice, I handled a case from Burundi. And one of the things they said specifically, like, for example, Article 142 of our constitution, they said the president of the republic, around the president, would not be liable to actions taken when he was president. And we have to strike down and to protect perpetrators of violence and other actions that are actionable. That is completely encouraging impunity. And we know in some countries that parliaments are bulldozed within one afternoon to pass laws that actually encourage impunity. And those who know the story of Kenya before 2010 will remember the story of the late Paul Ngei. Paul Ngei committed an electoral offense. President Kenyatta called parliament to order one afternoon. They amended the constitution to allow the president to allow a person who has committed an electoral offense to run for office again. And that was passed within one afternoon. And the next by-election, Paul Ngei ran for election and won. So when you use the constitution and parliament to amend laws to create actions that encourage entrenchment of impunity. The second is on policies. In Kenya, for example, you all know what happens when a political leader is arrested for corruption, for even violence. What happens? His community rallies around him. As a matter of custom, our leader has been arrested, and you all go to court as if a difference will be made by the numbers that you bring to court. My friend, the late William Olenti Mama, was once arrested and taken to court number 1 at the Supreme Court building today. The Maasai community, the Maa community I belong to, a rally around him, Morans carrying court to show that they're protecting their own. That is a practice, that is a custom, that is an act of impunity where your leader is charged with offenses and you rally around him because you must protect your own, whatever the offense. You may well recall also when the Goldenberg Commission of Inquiry was undertaking its processes, Kamlesh Padney, the main suspect being investigated, was being treated like a hero. And school kids would rally around him taking self-pictures. That time there were no selfies. Now, if that is a mentorship that you encourage our students to have, that is in fact a mentorship in impunity. And so, back to policies and practices, one of the biggest challenges that we must address around impunity is the fact that our laws, our practices, our customs favor only a few. The economic divide operate to shield those with means and resources as opposed to those that don't. And therefore, certain groups and classes enjoy greater merit and privilege, even within our courts. And therefore, you see police, court staff, they treat the rich, the wealthy, even the way they handle them as they come to court is different from how they treat Mama Mboga and the lady from Mukoro Kwanjenga. These practices, these policies, these customs encourage impunity within a state. One of the more fearsome of the manifestations of impunity is in fact about us, judicial officers. Where our attitudes affected by where we come from, or whether you're a man or a woman. And I know, for example, some colleagues who hold very traditional views about rape. If judicial officers themselves, by their culture, by their own actions, encourage impunity, where shall people go to seek solace? And so one of the thoughts that I had as I was thinking through this was, we must not just think about the laws, about the constitution, but also attitudes attitudes, practices, customs of people who are law enforcers at whatever level, including at my level. Let me now very quickly move to impunity at the international and regional level. We know that prior to World War I, the international community had not ever applied its mind to managing atrocities as a matter of international law. And therefore, until the Nuremberg and Tokyo tribunals, the world had not sat together to say, how do we address impunity as a concern across the globe? And so after the Nuremberg and Tokyo tribunals, we, of course, in the 90s had the International Criminal Tribunal, the predecessor to the Session Special Court for Sierra Leone Vice Seat. And all these were an attempt by the global community to human rights at a global level and also at the regional level, but affecting a larger community than just one community. And so investigation of genocide, crimes against humanity, and war crimes are now entrenched in the international world. And of course, we know of the ICC and the role that the ICC plays today. That in 2013, 2014, 2015, there was an attempt by Kenya to pull out of the Rome Statute. And you remember the huge diplomacy attempt by the government then to rally Africa to pull out of the ICC statute. And I know that a lot of us then and now were very, very worried that should we pull out of the Rome Statute, and the fact that the ICC remains one of the most feared entities in this country by politicians, we said it is a mistake for Kenya to pull out of the ICC. And even today, as we go through what we're going through, the fear of the ICC is real. And that is a good thing, because while it is looking up to you, then, my friends, the ICC must stay, because it's one of the tools we must use in this country to combat impunity. I would like to send you to look at the UN updated principles to combat impunity, and principle 1, particularly where the state fails to meet its obligations to investigate violations. I would like you to look at principle number 30, which is the need for states to ensure that judges have independence and that judges are appointed and removed in conformity with the principle of parallelism, and that judges are allowed to do their work without fear of victimization. Because if you victimize the judiciary, and we know this from, obviously impunity will thrive, because there is no agency independent enough to punish the powerful for offenses committed, including violation of human rights. So I would like you to look at those principles, because they guide some of the things that we must continue discussing in this country. I'll move very quickly to the case studies. And I'll begin with South Africa. I think we all agree that South Africa, during the apartheid regime, suffered probably one of the most despicable act of impunity. The system was dehumanizing, governance was based on race laws, and the government was drawn into a long and bloody war to preserve its policies of racial segregation and to fight to sustain the brutal apartheid system. That, my friends, must stand out as one of the most despicable acts of impunity. That the majority Black community is subjugated to the will and whims of the minority white community in all spheres of their lives. If that is not impunity, I don't know what is. And in South Africa, we must appreciate that the impunity was viewed via two lenses. One, the structural lens, and two, the functional lens. The structural lens is where legal institutional measures then were used to entrench apartheid. Today, it is a converse. The regime is working very hard to ensure that those laws and institutional measures strengthen accountability. So they are fighting back. It's a push back from what laws they found when the ANC took over. The functional aspect is where structures are put in place, but were deliberately undermined or underutilized or wired to perform poorly. And so that's why in the case of Bradley McCallum versus South Africa, the Human Rights Committee found that South Africa had violated Article 7 of the ICCPR after a mass assault of prisoners at St. Alban prison in 2005. So although we had independence, ultimately the new regime also was using some of the tools they found in office to perpetuate injustices against its own people. And that is why when those 554 people died in 2010-2022 in South Africa, the government was called to account. Where is that similar action against the Republic of Kenya? I'll come back to it in a minute. When have we ever sat down as a country to say, from independence to 2010, the number of people who suffered violations because of government action or inaction are the following? When have we done the census? The result is that a lot of people have disappeared in the system and they have never found recompense or compensation because we don't even know who they are. That is an act of impunity where the state, even after 2010, has not taken action, proactive action to identify perpetrators and punish them. The other thing about South Africa, which is worrisome, while South Africa came out of apartheid, today it is a Black community of South Africa against Black immigrants into South Africa. One of the things that, Victor, you may not know, you said I was a member of the Council of the Association of Refugee and Migration Judges. In fact, I am the president of the International Association of Refugee and Migration Judges for the last 3 years. And one of the things we deal with as an association is xenophobic attacks in South Africa. Because asylum seekers from Zimbabwe, from other countries, Eritrea, Somalia, Ethiopia, are going to try and eke out a living in South Africa, but it is a Black community that is being supported by the system that is attacking them in xenophobic attacks. That is impunity. The other thing about South Africa is, again, an issue I'll revisit, corruption. You know, when you throw out the white community and then you bring the Black community, and then it is exactly what John Githongo said, our time to eat. So that the whites had eaten, now it's our time to eat. The result is that both in public and private South Africa is sliding down the scale of corruption. And when the state, as happened in the Zuma cases, which you all know about, when the corruption rises the highest level and the president of the republic is actually sent to prison for corruption-related charges, that must tell you the bottom is rotting. And when you found in South Africa that when President Zuma is being taken to court for corruption cases, part of the ANC rallies around him, it is precisely what I said about Kenya. So we are allowing corruption to thrive and the impunity of corruption to thrive because we are popular within the party that took us to power. That is impunity. So I will quickly rush to what the judiciary of South Africa is doing. Section 165 of the South African Constitution provides for independence of the courts, and they must apply the constitutional laws impartially without fear or favor, a common phrase that we use. And I think, to speak for myself, one of the interesting cases in South Africa was a case filed against the Minister of Correctional Services, where he was ordered to pay 2.5 million rand from claims originating from assaults committed by correctional officers. Can you imagine one day the prisoners in committee, and they handled a case in committee where prisoners had filed a case in the Constitutional Court, the High Court, seeking compensation because they get paid, those who are serving long sentences work for the prisons. They make the chairs that some of us sit on in the courts. They also do take, they work in the farm, and they are being paid, I think, 5 cents a day, which is a rate that was given, I think, in the 60s. So they came to say, since we are working and we are entitled to something, why can't we have an amount that is commensurate with our services? In South Africa, that court ordered the minister to pay 37 million rand in compensating victims of injustice within the prison system. Why have we not done the same in this country? The other case that I would like to bring to your attention is the question of impunity by way of disobedience of court orders. Again, I'll discuss that when I come to Kenya. In the case of municipal manager over Tambo District Municipality versus Ndabeni, the court said, it is necessary to emphasize this court's repeated exhortation that rights and court orders must be respected. A court would not force compliance with an order if it's against the rule of law, but no court order ever flawed should be flouted with impunity. Again, in South Africa, we have had, especially in the Zuma regime, a large number of court orders not being complied with. And that, my friends, is certainly, in my view, an act of impunity. In the case of Secretary of the Judicial Service Commission into allegations of state capture, corruption, fraud in the public sector, they said, and this is the Constitutional Court, this court, public utterances impliedly not confirm that, this is about Mr. Zuma. The court cannot have reason to doubt the veracity of the applicant's assertions. In any event, the extent of the breach by Mr. Zuma has not been challenged by himself, who has taken multiple public platforms upon which he has affirmed the extent of his non-compliance. So when you have politicians, high-ranking officials going to the public to say, we shall not ever comply with that court order, that is an act of impunity. And courts must therefore become firm in enforcing those orders. And later I'll tell you my own example when a minister told me off on TV after I issued orders of arrest against him. Let me go to Nigeria. Now, if Nigeria is anything that we hear about, then Nigeria is probably one of the countries in Africa where impunity is encouraged by the deliberate subversion of institutions of justice and accountability. And there have been many instances in Nigeria where people have lost trust in the justice system. You may wish to know that whereas in this country we take mob justice as a good thing, in Nigeria, at one point, 727 people died within 3 years out of mob justice. And when you ask them why, they say, we don't trust the court system. We take these people to court and these people will walk away. They're being released by the courts. The other thing about Nigeria, which also speaks to our own problems in Kenya, is delay in the finalization of cases against perpetrators. And that calls for then the public to take the law into their own hands. And both are acts of impunity. If the courts take time for no particular reason to delay the finalization of cases, that's impunity. And then the converse is true, that when the delays are affected by the courts, the public then apply mob justice. Again, that's impunity. So impunity creates impunity. And yet, if you stop one, the other will be stopped as well. So Nigeria is one of the best examples of that seesaw balance between the public and the courts. The Human Rights Watch report on Nigeria also said that Nigeria is ranked number 150 out of number 180 in the corruption index. It's bottomed down completely. And this speaks to the fact that the challenge of corruption in Nigeria is bigger and affects more than just the justice sector. And I insist, corruption is an act of impunity. Let's then come home to Kenya. We know, and I don't need to speak to this too much, of the events of 1963 to 2010. The centralization of power within the executive, to the extent that you will not know the difference between the executive, the judiciary, and the legislature. phone calls, as Mutunga once told us, were being made directly, and there was a red phone on the CJ's table, which only rings when a call is made from State House. And Mutunga came and threw it away. That fusion, that link between the arms without separation of powers created huge impunity questions in our country. Multi-party democracy, human rights abuses, detention without trial, torture. All these were acts of impunity in our lifetime. Corruption. And I think we need to discuss corruption again in the context of Kenya and say, whereas we are focusing on corruption in the judiciary, and that's a very important thing to do, I think we must think of a bigger problem of corruption today. We have, as someone once said, devolved corruption to devolved units. Who's speaking about corruption in devolution? When billions of shillings are sent to Turkana or Samburu, where I come from, and you see no single tangible program of development, where is that money going? It is being eaten with impunity. And so we must have a conversation as a country around corruption, and not corruption in one institution, corruption across every institution. If we are to do a lifestyle audit for judges, let's do it across the country, for governors, for CSs, for PSs, for commissions. And if we don't do that, the fact that, for example, a lot of them are making money and we watch them make money and we take no action, that is an encouragement to impunity. And we are, as ourselves who allow it to happen, as culpable as those who commit the offense. Why don't you write about them in your theses? In your LLB thesis, write about corruption in devolution. Write about the answer to corruption in the country. Write about corruption and impunity. And so we need to address that question in the context also of corruption around displaced persons. Many years ago, we had many IDPs in this country. And the next thing we had, the food and money being taken to IDPs was being eaten in government offices in Nairobi. We know these things. Who's taking action? Where are the agencies we created to follow up on this kind of impunity? There are none. And so back to the judiciary. In 2007, I was a judge. I was the chairman of the Magistrates and Judges Association. The electoral violence happened. One of the things that pained me as a judge then and pains me today was the fact that one of the reasons that violence erupted was because one side of the divide said, we cannot trust the Kibaki judges, including myself. The moment you go to the country and say we don't trust the judiciary, where else can justice be found? And so, in whose hands are those 1,000 dead and 3,000 displaced? No, 300,000 displaced, 40,000 houses touched. In whose hands will that act of impunity fall? It may fall well within all of us. And so for me, as a judge and as a Kenyan, I think we must continuously fight any attempt at entrenching impunity within the judiciary of Kenya, because judiciary may well be the last front of the fight against impunity now and in days to come. And so we have a good constitution. We in the judiciary have got good pillars. Chief Justice Mutunga transformation framework. Chief Justice Maraga followed. Chief Justice Koome followed. If we were to apply all the 4 pillars of all those frameworks and punish perpetrators of impunity as a judiciary, fast track the hearing of cases, then I'm certain we shall fight impunity in ways that have not been done before. I'm rushing very quickly because my time is going. But look, if at the corruption level, Kenya still remains, as of 2022, 123 out of 180 countries, what are we talking about ourselves? What are we doing about improving our lot as a country? I think we have a big conversation, and you at your age and at your level must be the catalyst of that conversation. How then have we in Kenya attempted to address these issues? I think you know very well that Article 159 implores the judiciary to do justice to all irrespective of status, and that justice shall not be delayed. Article 22 grants every person the right to suit court proceedings for violation of rights. Article 157 grants the ODPP the mandate to prosecute criminals. But we must also speak about the issue that is live today. In the last 1 year, 2 years, we've seen withdrawals of cases. And I can speak about them because they are not with us in the judiciary. I'm not breaching the role of sub judice. I'm speaking about matters that are in the public domain. When we begin by taking people to court and then withdrawing the cases, what are we saying? That we never had evidence in the first place? Or are there considerations outside the law that have influenced the independence of the ODPP? Article 157 says ODPP shall act without any direction or control by any person. Is that true? Is there impunity in the way that the ODPP acts? In the case of Jirongo versus soy developers, the Supreme Court said as follows: we agree and adopt the position that the judge of the High Court was correct, that where a prosecution is being mounted to aid proof of matters before a civil court, or where the hand of a suspect is being forced by the sword of criminal proceedings to compromise civil proceedings, then Section 183 of the Criminal Procedure Code cannot be invoked to aid that unlawful course of action. What happened in the Jirongo case? And Jirongo, you may say anything about him, but in this particular case, he goes into a fight with his colleague in 1992. They fight over some land in Nairobi and they go to sleep. In 2002, the ODPP wakes up and says, oh, you stole this land. Yet there are enough judgments between these two gentlemen in the civil courts where the issue of ownership, the issue of transfers of the land is being affected. When the ODPP is used by one party to compromise proceedings before the civil courts, that is impunity. Or where a suspect is being forced to compromise a civil case because of the sword of criminal proceedings, that is impunity. And so in that particular case, the Supreme Court did allow the plea by Jirongo to terminate proceedings before the Magistrates Court. In the case of Dande versus Inspector General of Police, a very recent judgment of the court, again, the court laid down guidelines for abuse, for non-abuse of the criminal proceedings by the ODPP. And I won't read the guidelines except to say one. Where the criminal proceedings are being used in a manner to abuse the process of the court. If you use the process of the court, then that is what I'm calling impunity. Let me quickly go to contempt proceedings. Over the last many years, and speaking for myself, I have seen a huge number of people who treat court orders like toilet paper. And I've used many. I've seen many cases where, oh, that court order is not worth the paper it's written on. One time, President al-Bashir of Sudan, when he was served the indictment from the ICC, said the ICC can take its court order and chew it. We've had many of those. In the case of Githega versus Keruti Factory, the Supreme Court was clear that court orders must be obeyed, whether you like it or not. And I think any attempt at disobeying court orders would amount to impunity. I think the Miguna case versus the DPP, which you all know about, must speak to that fact. Similarly, the Jimmy Wanjigi case must speak to that fact. My point is, if we continue disobeying court orders, that is an affront to the rule of law. It's an affront to the independence of the judiciary, and it's a way of entrenching impunity. How then do we, as I close, how do we aid the public? How do we aid institutions? How do we aid the state in improving the enforcement of the law? Very quickly, the first one, I think the public must be made aware of the normative legal framework and procedural laws for them to access justice where rights are violated. Number two, I think the courts ought to wake up the reality that unless we impose firm sentences, both for violation of rights and for contempt of court, they will be repeated. And that is an entrenchment of impunity. Number three, we must continuously train magistrates and judges, law enforcers in the rights, in human rights standards, and also in the way they treat the public. And we must apply the law without regard to status, because in this country, we seem to have two laws, like I said. And very lastly, I think with the technology that we are using now in the courts, delay in filation of cases will come to an end. And those who are accused of offenses and are found guilty will be sentenced a lot more faster than we are doing. Just last week, those who may remember the Anglo-Leasing cases, the Anglo-Leasing trials came to an end last year, and they were first commenced in 2004. What does that tell about the system that we're operating in? And so, let me conclude by saying this. Whereas all actors and all agencies within the state have a very fundamental duty to enforce the law and fight impunity, I submit to you that the judiciary has got a bigger role, has got the most fundamental role. And if we lose the judiciary in the fight against impunity, we'll have lost the fight now and in days to come. I thank you very much for your attention. I'll take the questions that I've seen on the chat later. Thank you very much.
Thank you very, very much. Judge, I'm trying to locate on the emojis a suitable response to what has been a stunning input from your end. And unfortunately, I think they don't do justice. I only see the ones with happy birthday and celebration. But I think you have set the ball rolling for all of us. I would like to caption a statement that you made in all of this. I think the highlight for me was the system that you described, almost the semblance being of a vicious cycle of some kind. When you mentioned impunity creates impunity. And I see a lot of questions on the chat relating to that statement, where for one reason or the other, you set a vicious circle in play. I'm saying this because I'm hoping that John Ohaga's senior counsel will be able to speak to some of these points as he discusses generally what you have covered. I think the other thing that was very, very key for me is the question of trust in institutions. You gave us quite an array of things both in our country and outside our country, where the very basis of impunity is hinged on how the public views institutions. I think the classic was our 2007-2008 period, and the comments that we received again about the Kibaki judges. The other, I think, that is very key, and I think probably in your response at a later point, Judge, is this question of the social-cultural dynamic. I kept thinking, why certain countries do not have the same experience when it comes to rule of law and reaction to the decisions of the courts. The typical example that is given is of traffic lights, littering, and all of these actions in the developed world. And individuals operate in that world. They won't jaywalk, they won't cross traffic lights, but when they come back in our context, it's all free for all. So that, I think that was very, very interesting. Then I think from the case studies that you shared with us, I would be keen to hear from you, Judge, of a particular example of a society that has transitioned from high levels of impunity to the respect for the rule of law. So how have they done that? Are there low-hanging fruits that can be leveraged? What have the courts done in that kind of a society? So just to mention a few of some of the issues that you had raised. There are lots of others I can see on the charts. Questions about constructive criticism, the line between that and disrespect for decisions of the courts. We find we live in a terrain every time the court makes a decision, you attract both applause and disdain at the same time. And where do we, how do we signal maturity when it comes to us as a society and the way we react to those decisions? So those are some of the few points that have been emerging. At this point, I'd like to invite Mr. Ohaga to weigh in. I'm sure there are several thoughts from your perspective as a practitioner that were running through your mind. I'm sure you've also thought about this topic from beforehand. Please, karibu sana, John. There are questions in the chat. If at any point you choose to react to any of the questions, please feel free. Welcome, welcome, welcome. Karibu sana.
Good afternoon, everybody. Thank you very much, Dr. Mtuma. Let me just acknowledge the presence of my very good friend, my schoolmate, and he also failed to mention that we both undertook our pupillage at the same farm at different times. This was at Hamilton, Harrison, and Matthews. So thank you very much. I'm very delighted to share the stage with you, Justice Isaac Lenaola. I have not had the prior benefit of reading Justice Lenaola's presentation. And so I will try to offer a different perspective. I think he has dealt very, very competently with the challenges faced by the judiciary, with which he would be very intimately aware. I want to deal with the challenges in enforcing the law and combating impunity, and I want to deal with it in two separate aspects. First of all, I want to look at the role of lawyers, because I'm a lawyer in practice, and this is where I earn my bread and butter. But also I recognize that the majority of you on this forum are budding lawyers, law students, and therefore it will be illustrative for you to appreciate what is required of you as lawyers. And then I also want to deal with something totally different, because when we speak about impunity today in this society, we often think about impunity by state actors, impunity by politicians, impunity by people of that nature. But I also want to deal with the question of impunity and the challenges posed by corporations, because corporations also engage in acts of impunity. And so let me just start by saying that clearly enforcing the law and combating impunity are essential for maintaining a just and orderly society. The enforcement of laws ensures compliance, protects individual rights, and upholds the principles of justice. There are, however, numerous challenges that hinder the effective enforcement of the law and the eradication of impunity. As I said, I propose to deal briefly with the essential ingredients in the enforcement of the law and its correlation with the rule of law, the nature of challenges encountered in enforcing the law, before embarking on a discussion of the role of lawyers in enforcing the law. I will then turn to a consideration of the role of corporations in perpetuating impunity and propose potential solutions. So Let me address the question, the importance of law enforcement and combating impunity. As I've already stated, law enforcement plays a vital role in maintaining social order, deterring unlawful behavior, and protecting citizens from harm. The enforcement of the law involves monitoring, investigation, and taking appropriate actions against those suspected of breaking the law. Conversely, combating impunity refers to holding individuals accountable for their actions and preventing them from evading punishment or consequences, as has already been so well articulated by Justice Lenaola. When the law is enforced effectively, it serves as a deterrent. It discourages potential offenders from engaging in criminal activities. It also instills confidence in the legal system. It fosters trust in the judiciary and law enforcement agencies. But conversely, when impunity prevails, it erodes trust in the system, it perpetuates a culture of lawlessness, and it completely undermines the rule of law. As the scholar W.B. Gwain stated, the rule of law is the foundation of a civilized society, offering protection and security to all members of the community. The rule of law and the enforcement of the law are therefore closely intertwined and rely on each other to maintain order, protect individual rights, and promote a fair and equitable legal system. The rule of law is therefore a fundamental principle that upholds the idea that all individuals, including government officials, are subject to and must abide by the law. It ensures that the legal framework is transparent, predictable, and consistently applied to all members of society. As we all know as students of jurisprudence, the rule of law is guided by several key principles that are essential for its effective implementation. Number one, equality before the law. The law must apply to all individuals equally without discrimination or favoritism. It ensures that no one is above the law and that everyone is subject to the provisions of the law. The second tenet is legal certainty. That means that the law is clear, it is stable and accessible, thereby allowing individuals to understand their rights and obligations. It provides predictability and enables individuals to make informed decisions. Thirdly, there must be a fair and impartial legal system so that legal processes and decisions should be fair, unbiased, and free from improper influence. A fair and impartial legal system ensures that justice is served and that individuals are treated equitably. And fourthly is accountability. Public officials and institutions are accountable for their actions and must operate within the bounds of the law. Accountability ensures transparency, discourages corruption, and upholds the principles of justice. And so therefore you will see that the enforcement of the law is instrumental in upholding the rule of law. When law enforcement agencies act within the framework of established laws and procedures, their actions are seen as legitimate and acceptable to society. The enforcement of the law protects individual rights, ensures compliance with legal provisions, and promotes social order and stability. The rule of law, on the other hand, provides a set of checks and balances to prevent the abuse of power during law enforcement. It holds law enforcement agencies accountable for their actions and ensures that they operate within the law. When law enforcement agencies adhere to the rule of law, this enhances public trust and confidence in the legal system and its ability to protect the rights of citizens. Despite its importance, the rule of law faces various threats that undermines its principles and functionings. These threats can arise from both internal and external sources and pose significant challenges to the effective enforcement of the law. Identifying and addressing these threats is crucial to preserving the integrity of the legal system and upholding the rule of law. And so I've sought to identify what these threats to the rule of law and therefore to the enforcement of law could be. And the first, and I think the most pernicious threat that I have identified is corruption. Corruption within the legal system or among public officials is, in fact, a significant threat to the rule of law. When individuals tasked with upholding and enforcing the law are corrupt, it undermines trust in the legal system and allows for selective or biased enforcement of the laws. Corruption erodes public confidence in the efficacy and impartiality of legal institutions. Only yesterday or the day before, I was following on social media discussions around enforcement of the law, and specifically in relation to small crimes, and the question whether people would subject themselves to the law in relation to small crimes or would rather pay a bribe in order to escape the strictures of the law. And I'm sure that you must all be aware what the result of that poll would have been. The result of that poll was overwhelmingly an agreement that it is, in fact, easier to pay a bribe, either bribe a policeman or bribe a judicial officer in order to evade the inconveniences that come with dealing with small offenses, small infractions of the law, than face the consequences, even when you are innocent. And so corruption really, unfortunately, is at the foundation of our society and undermines every facet of our society, and therefore undermines enforcement of the law. The next Mr. dealt with, I think quite substantially, is the whole question of political interference. Political interference in the judiciary or law enforcement agencies compromises their independence and impartiality. When political leaders exert influence on and undermine the rule of law, the interference of political interests can distort legal processes and hinder the fair administration of justice. And we can all think and find instances when there has been political interference in some aspect or the other of our judicial functions or with respect to our law enforcement agencies. And that includes everything that we've witnessed over the last couple of days in relation to the activities that are ongoing in our country. The third is the arbitrary use of power. The arbitrary use of power by law enforcement agencies or authorities certainly acts to erode the rule of law. When individuals or entities exercise their authority without adhering to established legal procedures and safeguards, it creates a sense of injustice and weakens respect for the rule of law. The misuse of power undermines public trust and can and does lead to social unrest and instability. The fourth is perceived weak judicial independence. Judicial independence is crucial for the where laws are selectively enforced based on factors such as social status, to which Justice Lenaola already referred, ethnicity, or political affiliation, it undermines the principle of equality before the law. Selective enforcement erodes public trust in the legal system and perpetuates social inequalities. It fosters a sense of injustice and involves situations when segments of society lack access to legal representation or face barriers to justice, which results in unequal protection under the law. Limited access to justice diminishes the effectiveness of the rule of law and perpetuates social injustices. Addressing this issue requires efforts to improve access to legal services, to provide legal aid, and promote equal opportunities for all individuals in seeking justice. And it matters not that we have one of the best constitutions in the world in which access to justice is one of the pillars of our constitution. If access to justice remains merely a catchword, then clearly enforcement of the law cannot be achieved until every segment of our society, including the poorest of the poor, have access to justice. And then there is the use of emergency powers and security measures. In times of crisis or emergencies, such as we see now, there may be a temptation to suspend certain legal protections or rights in the name of security. While some limitations may be necessary for public safety, the excessive or prolonged use of emergency powers can lead to abuses and weaken the rule of law. Striking a balance between security measures and the protection of legal individual rights is essential for upholding the rule of law during challenging times. And this has become evident as we see the tension between the right to protection of property and the right to assembly and to protest, as has been witnessed again over the last actually couple of months, as we have seen the response and the reaction to the acts of civil disobedience, social unrest, which have followed what is now popularly called maandamano. And then lastly, but certainly not least, and something that Justice Lenaola has spoken at length about, is the disregard for court orders and for court decisions. When court decisions are not respected or implemented, that undermines the authority of the judiciary and weakens the rule of law. The failure to enforce court decisions again erodes public trust in the legal system and hinders the proper functioning of the rule of law. Upholding the integrity and authority of court decisions is crucial for maintaining the rule of law and ensuring justice. Now, having set that out very broadly as a background, I want to speak about the role of lawyers in enforcement of the law. Mr. Justice Lenaola said quite correctly that the judiciary is a key pillar in the enforcement of the law and in fighting impunity. But the judiciary would be powerless and could not function without the role of lawyers, because lawyers play a critical role in the enforcement of the law. They act as the backbone of the legal system. This is because their expertise and advocacy are essential in upholding justice, ensuring that the rule of law is followed, and protecting the rights of individuals. A lawyer's knowledge of the legal system allows them to navigate complex legal processes, to represent their clients effectively, and to ensure, hopefully, that the law is applied justly. Lawyers act as advocates for their clients, ensuring that their interests are protected and their rights are upheld. They offer legal advice, they negotiate settlement, they represent their clients in court, they interpret the law, guide their courts in applying the law, and they build strong cases and make compelling arguments before our courts of law, thereby allowing our courts to reach reasoned and decisions that can stand the test of time. By standing up for their clients, lawyers contribute to the overall fairness and integrity of the legal system. Indeed, without lawyers, the justice system, as I've said, would be incomplete, and the principles of justice would remain unattainable. And there are different categories of lawyers who are actors in the enforcement of the law and in fighting impunity. These include criminal defense lawyers, civil rights lawyers, each of whom have a specialized area of law and have a unique impact on the overall functioning of the legal system. As you will no doubt appreciate, law enforcement encompasses a wide range of legal issues, and therefore there are various types of lawyers who specialize in different areas of law. One, and the first significant category, is criminal defense lawyers, who defend individuals charged with criminal offenses. These lawyers play a critical role in protecting the rights of the accused, ensuring that they receive a fair trial, and challenging the evidence and procedures used against them. They are the advocates for those who are presumed innocent until proven guilty, and their expertise in criminal law is invaluable in safeguarding justice. Another important group of lawyers involved in law enforcement is prosecutors. These advocates represent the state and are responsible for bringing criminal charges against individuals accused of committing crime. The prosecutors play a crucial role in seeking justice for victims, holding offenders accountable, and ensuring public safety. They work closely with law enforcement agencies, gather evidence, and present the case in court. Their duty is to uphold the law and seek fair outcomes that reflect the severity of the crimes that have been committed. Now, a side comment here, where, of course, prosecutors appear to act under the influence of political actors or under the influence of other actors whose social standing allows them to exert influence, then certainly their role as one of the lawyers in law enforcement is significantly undermined. And the difficulty that arises is that it brings into focus and begins to allow the public to question even those decisions to prosecute which are reached on bona fide grounds, because their decisions are colored by the influences that are seen to direct the way in which they have made prosecutorial decisions. And so, as Justice Lenaola observed, in recent times, we have seen numerous cases either being withdrawn, charges being withdrawn, or charges being reduced in respect of persons who may very well be considered influential or have relation to political actors, and that significantly undermines the enforcement of the law. There is then another group, which is civil rights lawyers, who play a very significant role in law enforcement. These are lawyers who specialize in protecting and promoting civil rights, fighting against discrimination, and advocating for justice and equality. They work tirelessly to challenge unconstitutional laws and represent individuals who have been victims of civil rights violations and strive to create a more just and equitable society. Civil rights lawyers are at the forefront of social change, using the law as a tool to fight against injustice and systemic discrimination. Now, we have to look at ourselves as a society and ask ourselves the question, have we given up this position, regulatory frameworks, negotiating contracts, and resolving legal disputes. Their expertise in business law and their understanding of the legal landscape are essential in protecting the interests of the company and upholding the law. And I put public interest lawyers in the same footing as civil rights lawyers, and the same comments would apply to them. And so, having said all those categories, we would like to understand how lawyers contribute to the enforcement of the law. As I have already pointed out, number one, legal representation. Lawyers must equip themselves to be able to offer competent, quality legal representation. Where lawyers fail in offering competent legal representation, or where the quality of legal representation offered by lawyers is below a certain threshold, certainly the enforcement of the law suffers and impunity begins to set in. Lawyers also offer legal advice, and lawyers offer legal advice both to those who undermine the enforcement of the law, as well as those who seek to uphold the enforcement of the law. And the question that we have to ask ourselves, given that we're a forum of law students, is on which side of the divide will you lie? Because for every political influencer, for every person of social status, for every criminal escaping the tenets of the law, for everybody who seeks to evade the obedience of court orders, there is a lawyer offering advice. And so lawyers are at once primary actors in undermining the enforcement of law and perpetuating impunity, and at the same time seeking to uphold the enforcement of the law. Lawyers engage in legal research and analysis. They draft legal documents. They engage in negotiation and mediation. And I've said they ensure legal process. They advocate for access to justice. And lawyers are expected to uphold ethical standards and professional conduct. Recently, I was requested by the Law Society of Kenya to speak to the newly inducted advocates relating to professional conduct and specifically to professional etiquette. Because, as you know, lawyers are bound by strict ethical standards, and their professional conduct is vital to maintaining the integrity of the legal system. In fact, society looks to lawyers as a guide as to how society should approach enforcement of the law. Where lawyers are seen at the forefront of upholding enforcement of the law, society will follow suit. But where lawyers are divided in the enforcement of the law, society will be equally divided. And when society is divided in the enforcement of the law, you can certainly be sure that the center will not hold. Lawyers also contribute to legal reforms. As legal experts, they play a role in shaping and advocating for legal reforms and policy changes that can improve the legal system and ensure justice for all. As with any other facet of society, lawyers face challenges in law enforcement. One significant challenge is the overwhelming caseload that many lawyers have to handle. The legal system is often burdened with a high number of cases, resulting in limited resources and time constraints. This can impact the quality of legal representation and hinder the ability of lawyers to effectively advocate for their clients. Another challenge is the inherent complexity of the law. The legal landscape is constantly evolving, new statutes, regulations, a case law emerging regularly. Lawyers must stay updated with these changes and continuously enhance their legal knowledge to provide effective representation. Additionally, as you will no doubt appreciate, the adversarial nature of the legal system can create challenges because lawyers must navigate through contentious disputes, conflicting interests, and sometimes very emotional situations. And so, having tried to set out what I think is the role of lawyers and how lawyers should respond to this, I very briefly want to address some of the challenges that we have seen that are faced by lawyers and the response by lawyers in the face of impunity. Dr. Mutuma asked me whether I had some responses to some of what Justice Lenaola mentioned with respect to impunity. Justice Lenaola mentioned the Kamlesh Patni cases. Kamlesh Patni was surrounded by, I don't know whether to call it a plethora of lawyers, but those of you, if you cast your mind to 10 years back, will know that Kamlesh Patni had all the lawyers available to him that he needed to be able to maintain all the lawsuits that he maintained through the justice system. This was facilitated by lawyers, sometimes in not in a manner that upheld professional ethics and the professional conduct expected of lawyers. I recall that our firm was engaged by both the Central Bank of Kenya and by another of Kamlesh Patni's adversaries, Ketan Somaiya, in some of the litigation that he faced. But some of the ways in which lawyers perpetrated impunity was very simple. One of the things we found was that some of Kamlesh Patni's lawyers, in fact, maintained rubber stamps from the different law firms that represented some of the parties against which Kamlesh Patni was litigating. So that when matters appeared before court, they would be stamped with documents from these law firms, which these law firms had never in fact received. And so you would be at a loss as to how to deal with the matter before the court. Unfortunately, this was pre-2010 constitution, and there was a significant number of judges who were compromised. And therefore came the question of a weak judicial system. Judges who were well aware or ought to have been well aware of some of the things that were perpetrated by a litigant who appeared before them and yet endorsed some of the actions that were undertaken by these lawyers. In one instance, on the day of the bomb blast, one of my partners was appearing before a judge against one of Kamlesh Patni's lawyers in some of the litigation instituted by Kamlesh Patni. The judge refused to adjourn the case despite Nairobi essentially running helter-skelter because the bomb had gone off at the American embassy, which was not very far from the courthouse. Everybody else in the court, in the high court, had run off. The judge insisted on proceeding with the matter despite continued entreaties to adjourn the matter. Eventually, the judge found against, in this case, it was the Central Bank of Kenya. Eventually, the judge, immediately after hearing the proceedings, delivered extempore a ruling which was handwritten. My partner had the foresight to ask for a handwritten copy of that decision. Back then, you would ask the clerk to provide you with a handwritten copy of the decision. A handwritten copy was provided. It was photocopied, I think, without the knowledge of the judge. Eventually, after a notice of appeal was filed, the judge, recognizing that his decision would be appealed, took the time to craft a new decision in order to try and cover up some of the areas that would be potentially appealed. And so eventually, when we received the typed ruling of the court in order to present or complete our record of appeal, it was at complete variance with the handwritten decision that the judge had rendered immediately after the proceedings. So you can see that both lawyers and judges interplay in perpetrating impunity, especially in enforcement of the law and in advancing situations which undermine the enforcement of the law, even in the face of very, very obvious and challenging situations which would have impelled any court to adjourn until it was safe to be able to continue to hear that matter. There are many, many other examples that I would like to give in relation to the role of lawyers in perpetrating impunity. In one example, where I was sitting as an arbitrator, the arbitration was against a state corporation by a contractor. The contractor was seeking the recovery of various sums that were due under the contract. I was approached in circumstances which I will not go into in this forum by a lawyer for one of the parties who made it very clear to me that he had the consent of the opposing lawyer to approach me and offer me a significant amount of money in order to make a decision in favor of the claimant who was the contractor. Now, as I have mentioned, the respondent was a state corporation. And so obviously, these were going to be taxpayers' money, which would have been paid out on the basis of the award that I would have issued if I had been complicit in agreeing to accept the amount of money that was offered by these lawyers in order really to reach a decision that was not supported by the facts of the case. And in this case, it was fairly straightforward. What the two parties wanted was that I should make an award that would completely inflate the amount that would have been due to the claimant, and recognizing the limited avenues for appeal from arbitral decisions, they would then be able to ensure that the state corporation honored the award and thereby essentially laundered the payment of these monies. Behind these lawyers were other political influencers who were waiting at the end of the pipeline to receive that significant amount of money. When I eventually made my award, which was for what I thought was rightfully due to the contractor, I can assure you that I received a significant amount of vitriol, both from the lawyers as well as political actors, some of whom had already intimated to me through their intermediaries that the decision that the lawyers wanted had their support, and that I would essentially be covered. This is impunity. This is how lawyers, judges, arbitral institutions, and now I speak as an arbitrator, pervert the course of justice, undermine enforcement of the law, and promote impunity. But since I'm running out of time, I want to speak very quickly about the other subject that I thought I would speak about, which is corporate impunity. Because we do not often think about corporates as engaging in impunity. Corporate impunity is a term that has gained significant attention in recent years, and this sheds light on the dark side of corporate behavior. It refers to the sense of impunity or immunity that corporations seem to enjoy when it comes to their actions and consequences. In simple terms, corporate impunity is the idea that corporations can act without fear of legal or ethical consequences for their actions. Corporate impunity is rooted in the idea that corporations as legal entities are separate from their owners or executives, making it difficult to hold individuals responsible for their actions. This concept allows corporations to engage in unethical practices such as environmental pollution, labor exploitation, and financial fraud without facing the appropriate repercussions. There are numerous examples of corporate impunity cases across the globe. Across the globe, for instance, we might refer to the Deepwater Horizon oil spill in 2010, where BP's negligence led to the largest environmental disaster in legal history. Despite causing immense harm to the environment and to local communities, BP in fact faced minimal legal consequences and continues to operate with limited accountability. Another example globally is a Volkswagen emission scandal, where the company deliberately manipulated the emission tests to meet regulatory standards. Although Volkswagen faced legal repercussions and financial penalties, the individuals responsible for the decision-making likely escaped personal accountability. Closer home, we have seen the consequences of corporate impunity and increasing attempts to address this. These include, for instance, the allegations against Kakuzi in relation to the mistreatment of alleged trespassers and those who it is alleged go into the pineapple plantations to help themselves with Kakuzi's products, and the manner in which Kakuzi's guards deal with them, the brutal manner in which Kakuzi's guards deal with them. We've also seen the ongoing proceedings in Scotland against Unilever and its subsidiaries. But in both the Kakuzi and the Unilever litigation examples, I think we have to give great thought to the fact that in both instances, the aggrieved parties have sought to commence proceedings in the courts of England and Wales on the basis that the remedies available to them in Kenya are inadequate. Does this speak to an inadequacy of legal remedies, or does it speak to a legal structure that does not support or does not allow us to curb impunity by corporations? Or does it speak to the fact that our judiciary is unwilling to impose the necessary financial sanctions and other sanctions that would bring these corporations, that would really essentially enable the parties that are aggrieved by the acts of these corporations to accept that they can find justice in our courts and not have to look to courts in foreign legal systems. Corporate immunity or impunity has far-reaching consequences for society as a whole. Firstly, it erodes public trust in corporations and undermines faith in the system. When corporations are seen as above the law, it fosters a sense of injustice and reinforces the notion that the powerful can act with impunity. This erosion of trust can have profound implications for social cohesion and the overall functioning of society. Secondly, corporate impunity perpetuates inequality and exacerbates social disparities. Corporations with unchecked power can exploit labor, pollute the environment, and engage in unfair business practices, all of which disproportionately affect marginalized communities. Without proper accountability, these corporations can continue to perpetuate harm without consequences, perpetuating a cycle of injustice. Lastly, corporate impunity hampers sustainable development efforts. When corporations prioritize short-term profits over long-term societal and environmental well-being, it undermines efforts to achieve a more equitable and sustainable future. By evading accountability, corporations can continue to prioritize their own interests at the expense of societal and planetary health. I will jump very quickly to my conclusion because I know that we're already at 4 o'clock, which was the time allocated for this, and in order to allow for a meaningful question and answer session. There are steps that individuals can take to challenge corporate impunity. First and foremost, as individuals, we must educate ourselves. We must stay informed about corporate practices and their impact on society. And we must support ethical businesses. We must choose to support businesses that prioritize ethical practices and that are socially responsible. As individuals and as lawyers, we must engage in activism so that we join or support movements and organizations that work towards corporate accountability. And we must advocate for legislative change in order to support legislation that promotes corporate accountability and closes regulatory loopholes. And lastly, we must be responsible consumers. We must question the products and services that we consume. We must consider the environmental and social impact before making purchasing decisions. By making conscious choices, we can encourage corporations to adopt more responsible practices and to therefore curb the instances of corporate impunity. I've referred to the seminal work by somebody called Bert Stevens, in which he refers to the immorality of profit, transnational corporations and human rights. And I've made other comments relating to corporate impunity, which I will not go into. Dr. Mutuma, please allow me to stop now so that there can be a question and answer session, and so that I can interact with my friend Justin. Thank you very much.
Make sure there's no echo from my end. Yeah, thank you very, very much, John. Actually, we were so intrigued by everything that you said right from the onset. As you can imagine, there is quite an array of students that are on this platform, and they are contemplating their future careers. So at the very onset, your discussions around what the LLB program means for them and where they will end up, and not just viewing the bar as one unified whole, but there is so much in that stratum that many of the students that are presently on will find fulfillment and will meet up with their career aspirations. I would rather, at this point, like to open up a discussion. And the way we'll do this, we'll try and be quite brief because the questions have sort of overwhelmed us. I will attempt to summarize what has emerged from the platform. And in no order, just ask both Judge and John to weigh in on the matter. One of the fundamental questions that has arisen is around trust, the question of trust in institutions. And how does the judiciary further trust? I think there are one or two cases that have been highlighted where trust could be actually sabotaged. The other, of course, is what you spoke to at length, John, public interest litigation. Why is it that that vacuum is being filled by Senator Mtata? What is it in our program as both here at the University of Nairobi, at the Kenya School of Law, that does not prepare our students, scholars to move into that platform? What happens when people actually do get admitted? Why are there very few advocates that are moving into that space? Then, Judge, I think there is quite an array of questions around law and language. You spoke about various impediments to access to justice. In colloquial terms, the contributor talks about the language that we use in formal institutions and how it alienates the vast amount of public. I know there's been a huge debate in this. Sometimes it rolls over into dress codes and so forth. And I think even the judiciary had a stint at the very beginning of the 2010 Constitution where the question of the courts and the way they present themselves to the public took center stage. Then, John, there is a question around greed. And this sort of points to you, the person of John Ohaga Senior Counsel. How are you able to reach the kind of conclusions that you reached faced with what is the common display of temptations in this area? What is the mark of integrity that you have, and how have you acquired it? Is it something that can be taught? Is it something that we should be doing at the university? Is our courses on professional ethics a bit intellectual and theoretical, or there are a certain other